The U.S. Supreme Court has issued an important decision on LGBTQ rights in the workplace, and the decision will be important in education in several ways. The court ruled in Bostock versus Clayton County, Georgia. The central legal question in these cases was whether discrimination on the basis of sexual orientation or transgender status was prohibited by the Civil Rights Act of 1964. Now, why is this important in education? For one thing, school districts and colleges are pretty big employers, so they face the same workplace and employment issues that other organizations deal with on a regular basis. And in this case, the national teachers unions, NEA and AFT, they've supported LGBTQ rights for a long time in the Supreme Court and elsewhere. And they filed a brief in support of the employees in these cases. And significantly, they were joined on that brief by groups that represent school boards and school superintendents. And all those groups said that reading Title VII to embrace coverage of LGBTQ workers would help create quote, a powerful and effective workforce and would ultimately help students. The other way these cases are potentially important for education is that many courts have analyzed Title VII similar to Title IX of the Education Amendments of 1972. And under Title IX, in recent years, we've seen a lot of questions about the rights of transgender students, whether they can use restrooms and locker rooms consistent with their gender identity, and whether they can participate in athletics on that same basis. These cases have not just been in the back of the minds of the advocates and the justices as they considered these Title VII cases, but even in the forefront. Justice Neil Gorsuch, who's President Trump's first Supreme Court nominee, he wrote for a 6-3 majority and said this: in Title VII, Congress adopted broad language making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognize today a necessary consequence of that legislative choice. An employer who fires an individual merely for being gay or transgender defies the law. Justice Brett Kavanaugh, who's President Trump's other nominee to the court, was one of the dissenters, and he said, I believe that it was Congress's role, not this court's, to amend Title VII. Justice Samuel Alito wrote quite a long dissent, which was signed by Justice Clarence Thomas. He called the majority opinion preposterous and also said the majority was acting more like legislators than judges on these issues. But Justice Alito's opinion discusses education quite a bit. On bathrooms and locker rooms, something that's come up in schools, Justice Alito says transgender students will be able to raise claims under Title IX that they should be able to use facilities consistent with their gender identity. Now, he has concerns about that, and he talks about some of the school cases that are out there. In the area of girls and women's sports, Justice Alito worries that transgender female athletes will take spots that are, in his words, reserved for females. Finally, in the area of gender pronouns, Justice Alito discusses with some concern the movement to use gender pronouns preferred by a transgender person. He notes a lawsuit in which a high school teacher claims he was fired for failing to use the student's preferred pronouns. Justice Gorsuch, in the majority opinion, says those issues were not before the court in these cases that were decided. He said, under Title VII, we do not purport to address bathrooms, locker rooms, or anything else of the kind. Some of these education-related issues that Justice Alito identified, we may see the Supreme Court's decision applied by the lower courts very soon because there are several pending cases where that could happen.